Good morning. My name is Mark Silver. I'm presenting a series of forensic seminars on YouTube for immigration and criminal lawyers, also civil litigation lawyers. These are programs that I've presented as continuing legal education credits for a number of private providers in the United States over many, many years, having lectured to tens of thousands of lawyers. I'm putting them on YouTube so that they're free for everybody and immediately available. I've really tried to encourage national organizations such as National Association of Criminal Defense Lawyers and state organizations to have these available to their members as well, with some success depending on the organization. These are really some of the most crucial CLEs for lawyers in these categories. I'm a lawyer myself. I don't practice, to the terrible embarrassment of my mother. I've been doing forensics since I left law school in 2002. And my underlying interest is to help lawyers to better understand their clients, help them to better advocate for their clients by understanding their issues and humanizing the case. The goal is for the lawyer to be able to elicit information in a more professional manner, to better understand not only the immediate issues for the client, but facts in the case and as it relates to relevant statute or case law. The topic today is something which I think is absolutely crucial for criminal defense lawyers in the United States, and that is the pre-sentence investigation report by the probation officer. I've seen many of them over the years in different contexts for different issues, for very different kinds of clients, inside New York and outside New York. And the single thing that binds them all together is that they're incredibly inadequate. And what I'd like to do today as a psychiatric social worker and someone who has a background in psychology and political science, to critique the pre-sentence investigation, the report, its structure and what it's made up of, and provide some ideas of how to counter it for the criminal defense lawyer with the assistance of a mitigation expert such as myself. There are a couple books that I recommend. They're on my website, markssilver.com. All the information's on my YouTube channel. But one is the Handbook of Mitigation in Criminal Immigration Forensics. The 7th edition came out not long ago. And it specifically deals with many of the topics that we cover in the CLEs and the programs through YouTube for criminal defense lawyers. The other book is Psychosocial Evaluations and Consultation. One of the reasons, or perhaps the primary reason I wrote this book, is because I often have questions from lawyers simply asking, how do you undertake an evaluation? And in fact, that's the most common question I get from lawyers, because when we're in law school, there's no course for us that teaches us an outline or strategies that point to how to elicit core information from the client, not only for the particular legal issue that the client presents with, but more generally to get a sense of who the client is, their needs, concerns, challenges, and so on. And that second book, Psychosocial Evaluations and Consultation, lays out in a lengthy but very, I think, readable way, a way to engage with the client as clinicians do. So why is this so important? It's important because of the shift in power in the criminal justice system. It was at one time a tripartite system of judge, prosecutor, and defense lawyer, and it's become in many ways a unilateral system now in which the prosecutor acts as prosecutor, judge, and jury, and in many instances the judge really doesn't have a lot to do because there's such a high rate of cases that are settled before trial. It's had a major impact on evidence, in my opinion. Law school requires an entire course on evidence for good reason. And today, evidence cannot be fairly examined in a court of law because of the cost and the risk of going to court. It's just too high for the defendant, and we also know that is the trial penalty. Paradoxically, hearsay evidence found in the pre-sentence investigation report and mitigation reports by mitigation experts such as myself have really become very crucial sources of information for determining sentence outcome. What I'd like to do, and I know many criminal defense lawyers watching today are familiar with the PSI, but I just want to go over very briefly what the pre-sentence investigation report entails. As many know, after a defendant enters a plea of guilty to a federal offense or is convicted by trial, he or she will meet with a probation officer. Typically, at the initial meeting, the probation officer from the Federal Bureau of Prisons will conduct an interview with the defendant to gather various kinds of information, including family history, community ties, education background, employment issues, physical, medical health, mental health, emotional, psychiatric issues, if there's been a history of alcohol or substance abuse of any kind, financial condition of the individual, and frankly, the willingness of the individual to accept responsibility for his or her offense. The probation officer will gather a wide range of evidence from many sources, may conduct a home visit, and then will render, after the investigation and interviews, a pre-sentence report. And it's really to assist the court by verifying, evaluating, and interpreting the information found. It's really supposed to be objective. It's really an investigation into the offense of the conviction, and to really find if the person, in addition to this particular wrongdoing, has any other history of wrongdoing, has any uncharged criminal conduct that may even be related to the present offense, the impact of the offense on the victim, and what are possible sentencing options. It's supposed to be a comprehensive approach to assess risks posed by and the needs of offenders under supervision, whether this individual ends up with incarceration or home confinement or some other sentencing outcome. There is an opportunity to make changes to the report. The criminal defense lawyer can object in various ways. This is absolutely crucial for mitigation because so much is uncovered through a mitigation evaluation because it entails a broad psychosocial clinical look at the person's background, challenges, issues in their lives that can help challenge the PSI. The main thing I want to stress again is that what I found over these years is that the pre-sentence investigation report by the probation officer are terribly deficient. There's a dearth of information missing in a wide range of areas, and I want to go over them briefly today. The first is that they're almost always misleading, in some ways incomplete. There's insufficient sections of information. And for me, the bottom line is that a half-truth is no truth at all. I will sometimes look back after I finish a mitigation report, and I look at the PSI after I complete my mitigation evaluation report, and I just stare in disbelief at the two reports are about the same person. The PSI and the mitigation report is supposed to be about the same criminal defendant, and they look like they're about two completely different people, and it's not supposed to be that way. In theory, the probation officer's report and my report should in theory be somewhat similar because we are looking for very similar areas in terms of information gathering, and we're gathering the information through very similar sources, not only documentation, but eliciting the information from, obviously, the criminal defendant. And, I often talk to criminal defendants' family and even friends and so on. But at the end of the day, they're very, very different. And the reason they're different is quite obvious. The probation officer does not have clinical training. And they have a very different ear. They have a very different sense of what kind of questions to ask. And even when they get answers, and I've seen this, I've seen mitigation, I've seen probation officers undertake cases, they're just not clinically in tune. They're not clinically sensitive. I'll just give you one quick example. I often get answers from clients, and I just don't believe them. It's not that they're lying, but the issue that they perhaps are being asked about is quite painful. It could be embarrassing or shameful in one manner or another. It could be an issue from childhood, for example, that they've never spoken about before. And you need some kind of clinical training to be able to engage in with this person in order to elicit the information and have them feel sufficiently secure to talk about these things in a way that will allow the information to come out and be reflected in the report, whether it's my mitigation report or for the probation officer. Second, there tends to be, I must say, a general lack of empathy. The omission of empathy is also the omission of humanization. And as I said at the beginning, that's my core concern as a forensic expert is to humanize the case, to have the court or even the lawyer who's dealing with the case immediately to understand the client in a more humanistic way. It's crucial to humanize the client and explain various aspects of the client's psychosocial background so that the judge or prosecutor will be able to identify with major challenges, traumas, and stressors that the individual has encountered. This is not easy to accomplish and requires a combination of objective information, subjective perspective, and clinical know-how. This is particularly important where the client has been demonized. And the two typical cases I see where this occurs is in child pornography cases and, quite frankly, white-collar crime cases. In child pornography cases, there's incredible bias and prejudice, and there's just a lack of empathy. And yet, in a child pornography case, like in any other case, it's important to understand who this person is, their judgment, decisions, maybe even more important in these cases, to understand how they got themselves into so much trouble. And I've spoken about it in other CLEs I've done. In white-collar cases, there's a lack of empathy because the white-collar defendant is just demonized. There's the sense that often the white-collar defendant has been given every opportunity in life. He's, gone to high school, college, often comes from a stable family and has, professional career, a very high income. And the sense from the prosecutor and often from the community is, why should we have any empathy for this person? And it's a huge problem, and it's something that really needs to be countered through a mitigation report because empathy is crucial in understanding a human being. And the reality is you don't know what went on in this person's life. Maybe they've had challenges and trauma and all sorts of issues that are not immediately evident, and we have, these biases because it's a white-collar criminal defendant, and it's terribly unfair. And I've spoken about this much more at length in my white-collar program. I also see a lot of criminal defendants who have done a lot of good deeds. It includes charity work, volunteer work, positive membership to religious organizations, their church, other organizations. And I don't see this accurately reflected in the pre-sentence investigation by the probation officer. Good deeds takes energy. It takes time. Volunteering takes time. Giving of yourself takes time. And it's important to understand the person's history of good deeds. And I hate to say it, but even after the criminal act has occurred. I saw a white-collar case many years ago, and it was a fraud case at a bank. And the the client really used very, very little of the proceeds for himself. He was a good human being. He had no criminal record. He did this in a moment of anger and terrible misjudgment. And he used the money that was taken through fraud, and part of the money he used was to help a family who very tragically lost their home in a fire in northern Manhattan in New York. It's not to excuse his fraud, his white-collar fraud, but you get a sense of this person's overall values by him, redirecting the money towards helping others who have been in need, rather than buying, a $300,000 sports car, for example. Another huge area that's missed in the probation officer report is general psychosocial information. Sometimes the PSI looks like a background check for a job interview rather than a psychosocial history. But, a holistic, complete psychosocial history is absolutely crucial in covering any and all background information that better explains how the client got to be in his or her current situation. And that's really what we need to do in order to reflect the statute criteria for sentencing purposes. In a sense, psychosocial history is mitigation in and of itself, because it better explains the client's decision-making, thoughts, feelings, and so on. The psychosocial information is not supposed to be solely concrete in nature, but individual in nature and reflect something about the nature of the individual. In other words, for example, sometimes I'll see in a PSI that the client went to this school, then this school, then this school. Well, why did he go to this school and this school and this school? It may be because he had a single mom who was struggling terribly, and they had to repeatedly move in the child's early years of development because they couldn't afford rent in one apartment or another, and this relocation necessitated changes in schools also because they were in different school districts. Or maybe, the child had a history, for example, of suffering physical and emotional bullying, and that's the real reason that the child had to switch schools over and over. So concrete information is good, but it doesn't provide the nuance of what was really going on in the person's life. General mental health information is just terribly presented in the PSIs. In the large majority of cases, what I often see are probation officers who basically ask the defendant, do you have any psychiatric history? And the criminal defendant will say, not really, no, I haven't seen a psychiatrist. I've never been given medication. And this might be true, but has nothing to do objectively with the mental health of the individual. Mental health issues can be overt, but they can also be subtle, chronic, acute, and the criteria and symptoms of each problem need to be explained. It's not just about emotional health, although that's very important, but general psychological well-being. Psychiatric diagnoses are important, but we want to understand how the person presents with their psychological or mental health issues. Clients may have had a history of mental health problems, PTSD from childhood or whatever, and the child grows up through adolescence and young adulthood and is generally functioning well, but there are these subclinical issues or maybe even atypical issues that are present that the client himself or herself may not even be aware of. So general mental health means general mental health, the overall mental health picture of the person, how that person functions, and we want to understand specifically patterns and functioning, meaning that if a person has changed jobs over and over, if the person has had many intimate partners, if the person has had consistent difficulty with communicating with family members, these are all red flags that there is perhaps undiagnosed or unrecognized mental health issues that require consideration. Family is not adequately interviewed or assessed, in my opinion, by the probation officer. I want to know about who can be interviewed, what kind of information they can reflect. I also want to know about the client's family development context, his own contacts with family, dependents, hardships, and so on. I'll give you one huge example. I see a lot of clients who are second generation survivors of the Holocaust in Europe, where Jews suffered overwhelming racism and harm and death and persecution, human rights violations, and so on. And many survivors and their families had relocated outside of Europe to places like the United States. And there is incredible intergenerational trauma that affects the second and third generation and so on. This is seen clinically, but it's also documented through research. This is just one example of family intergenerational issues that are missed. I live in New York. A lot of the cases I do are in large cities, including New York. I've done cases in Los Angeles, California, and Los Angeles, Miami, and so on. One thing about the United States is that we're a nation of immigrants. And a lot of the immigrants, and my real specialty is criminal mitigation for immigration defense lawyers, which I have other programs on. Many of these clients that have come to the United States, or their parents that have come to the United States, have come from places where there's terrible poverty, the ubiquity of alcohol or drugs, corruption, social and political unrest, all sorts of problems that cumulatively add up to extreme hardships for that family. And, your client himself may be an immigrant to the United States, living here legally or illegally. And so family development background, these issues are crucially important and need to be asked about and interwoven in the evaluation and ultimate report. Community environment is also not really asked about. So many of our clients have grown up in deprived socioeconomic neighborhoods with violence, prostitution, drugs, poverty, racism, and systemic abuses in the home or even outside of the home. And it's important to be able to document that and understand that. Clients who've enjoyed a strong middle-class background, who do not have their environments investigated fully for the possibility of unseen trauma, are really at a loss. And as I said before, this is really typical in white-collar cases. You see someone who shows up and, they're dressed well, they're very educated, they seem quite stable and secure in their job and so on. And you just don't know a person's life or what's really affected them unless you ask questions and inquire with particular care without any bias or prejudice as to who the person is. I'll tell you something very interesting. On the other hand, I saw a client whose family did very well. They had relocated from Puerto Rico, and it was 6 boys, and they had all done well. They all finished university. 3 of the 6 had started their own businesses, quite successful. None of them had alcohol or drug problems. They remained very close with one another. Their respective wives and their kids, the cousins, were all very close. They had many family outings together. But this family had grown up in a terribly deprived community, actually 2 terribly deprived communities in New York with a lot of violence and drugs. And they came out basically unscathed. And I asked, what happened? I had to ask, why isn't it that you and your brothers didn't have greater problems? And frankly, greater problems with the law, using drugs or alcohol. And they said, our parents would not let us interact with the community. We went to school, we came home. All 3 of us studied karate. We went to the dojo, 2-3 hours, we'd come home. And they had a lot of friends, the client and his brothers. They were all in their 40s or so and 50s. I said, how did you have friends? And he said, well, my mom said, if we want a friend, invite them for dinner, hang out at the home, but you're not hanging out on the street. And it was a really good example of parents who had been able to shield the children from harm in the community, which was very immediate, and allow them to grow in a safe and healthy manner, despite the incredible problems just on their doorstep. There's also cultural sensitivity that's required with these kinds of cases with regard to family, community, ethnicity, even religion. And I generally find that's lacking in the probation officer's report. That's not only with regard to how the client now lives his or her life, but the client's background and development. And the cultural sensitivity will also give a window of insight into the client's value system, judgment, and so on. In terms of willingness to accept responsibility, it is something that probation officers inquire about. But I see clients who are sometimes so incredibly remorseful. They profess really profound contrition for getting themselves into problems that led to this criminal issue or that criminal issue. And it's not really fleshed out. And it's great that they accept responsibility. It's great that it's in the probation officer's report. But the extent of the person really saying, I'm truly taking responsibility for what I did. I'm not just saying it. It's not just words. And I really will make a concerted effort to redirect myself in a way that ensures that I avoid repeating this kind of wrongdoing, I think also needs to be expressed through the mitigation. The last thing, and for me it's the most important, which is missing in the probation officer's evaluation report, is mitigation itself. There's a wide range of mitigation that's available for consideration. I have completely separate programs on different kinds of mitigation for white-collar work, for clients with borderline personality disorder, complex trauma, and so on. But it's not an investigation into mitigation, and I'm not sure why that is, because mitigation ultimately is a cornerstone of sentencing. And the way to counteract the probation officer's report is through a professional mitigation evaluation that also considers clinical issues in the widest sense. I just want to go over some of the kinds of tools available to elicit and understand the client. And the first one are neuropsychological evaluations. Neuropsychology is concerned with relationships between the brain and behavior. Neuropsychologists conduct evaluations to characterize behavioral and cognitive changes resulting from central nervous system disease or injury, including things like Parkinson's disease or other movement disorders. The neuropsychological evaluation involves an interview and the administration of tests, typically pencil and paper tests. These are standardized tests given in a standardized manner, and they're scored. These scores are interpreted. There's usually a conclusion that's provided by the neuropsychologists. And they look at functioning in a number of areas, including intelligence, executive functioning. Executive functioning refers to planning, abstraction, conceptualization, and so on. Attention, memory, language, perception, sensor motor functions, motivation, mood state, emotion, all sorts of things, quality of life issues, personality styles. And they can usually be quite powerful in how they present because it considers a wide range of possible pathology. It can be helpful in assisting in differential diagnosis, for example, to determine whether a possible mental health or behavioral change is related to perhaps a movement disorder versus depression or another brain disease or treatment that may be required. So there are different kinds of issues that the neuropsychologist looks at. It may provide a baseline against which subsequent evaluations can be compared so that doctors can decide whether functioning has declined because of the disease process or document whether functioning has worsened or improved as a result of interventions that have been provided, such as medications or whatnot. There's some real advantages to neuropsychological evaluations as a means to counter probation officer reports. It may be based on a wide range of investigative standardized tools ultimately that provide an objective sense of the client's behavioral and cognitive functioning. It can be helpful to rule out, as I said, organic brain disease and also reveal areas of daily functioning, especially where the client may need assistance or indicate rehabilitation potential. But there are limitations. The questionnaires and research tools used to evaluate the client, they often miss out on nuanced mental health issues and psychosocial background information and other subtleties. I don't use testing myself. I'm not saying it doesn't have a role, but, and I have this in my new book on borderline personality disorder, the advantages of a interview where you elicit information directly from a client, asking questions in a wide range of areas through holistic psychosocial assessment, is that every time you have an issue and an answer as a result, you can tackle the answer provided by the client and turn it over, understand it better. And I'll just give you one very basic example. One of the questions asked in many tests regard sleep. Is your sleep good? Is it poor? And so on. And clients, when they answer that question, usually tend to answer it in a concrete way. Yes, no, or whatever. But when you ask a client about sleep issues, you get much more personal, detailed, and nuanced information. I want to know if the client is sleeping at all versus sleeping 2 hours. Does the client get up in the middle of the night? Is this not about sleep at all, but about underlying anxiety issues? Is the client very obsessive and has thoughts that whirl and whirl and whirl around the client's mind, preventing adequate rest? Is this another issue, such as recurrent nightmares or bad dreams? Is it physiological? Is this client suffering intermittent night terrors or night sweats that doesn't allow the client to get a good night's sleep? And I find that with the standardized tests, you get standardized answers. But with a clinical interview, you will get clinical, personalized information in return. Another area of testing is psychosexual evaluations. Sexual development is often relegated to the backbench, so that a psychosexual evaluation to examine specific issues can be quite helpful. This is particularly if the client has had a personal history of challenges or trauma in this area. The limitation is that normal developmental phenomena is often mistakenly pathologized. For example, with appropriate sex play and exploration, we often have issues that are very delicate and difficult to explain to the court or to a lawyer, but it may be, in fact, quite age appropriate. I had a case many, many years ago where a client who was a teenager, who's a young teenager, had same-sex interaction with another individual who was a cousin who was, I think, 2 years younger. And the parents went ballistic and they reported this, and the prosecutor went to town on this. And, obviously there's a legitimate concern where perhaps a 13, 14-year-old is having sex play with a same gender cousin who's 2 years younger, or whether it's a different gender cousin. But what I did through the evaluation, that I tried to explain that this was a child who had no history of inappropriate behavior in any other way. And I tried to explain that same-sex and sex exploration in general is quite common and quite normal. And this is done through, you know, kids and adolescents reading about it, sometimes seeing it through social media, through self-exploration and other exploration. And there are a lot of things within human development and mental health in general that are really normative in reality and objectively, but someone not familiar with it can become very frightened. By the way, I see this with drugs. Experimentation with drugs is quite common in the United States, at least. And the number of people who experiment, whether it's with alcohol or marijuana or cigarettes or whatnot at a relatively early age, don't go on to form addictive behaviors to those drugs. And that's another area where sometimes you have to have a sense of what's normative versus what you're seeing empirically. There are psychological evaluations. Psychological evaluations tend to focus on conscious behavior in a broad manner, sometimes with or without objective testing. Psychological evaluations may omit a fuller consideration of emotional issues as understood in the context of development, family, environment, and community. It's extremely important to understand that decisions are not made through rationality. We're not rational creatures. All of economics, a good part of psychology, and even law is based on this. We make decisions based on our emotions, on how we feel about something, and then we rationalize it afterwards. And sometimes psychological evaluations miss out on that difference, on that nuance. Of course, you have psychiatric evaluations to counter PSIs. A mental health evaluation is done by a physician. A psychiatrist is a physician who has specialty in mental health. Psychiatrists tend to look for patterns of pathology. And that means not a moment of sadness or difficulty with sleep or appetite, but patterns that reflect a real problem which can indicate a pathology, a mental health diagnosis. Some areas are often missed out in psychiatric evaluations. Unfortunately, paranoid conditions and delusional systems may be undetected because they're quite subtle, or the client may be quite good at guarding against presenting that information to clinicians or others, or even family members. The problem with psychiatric evaluations is that they miss or they undervalue or neglect social and community issues. And we're social animals in many ways. We're political animals. We're community animals. And those issues need to be carefully considered in any mental health evaluation. You should also know that in the United States, about 2/3 of all psych medications are prescribed by non-psychiatrists. So the idea of wondering to yourself as a lawyer or whoever, has this person been evaluated by psychiatrists? And if so, that will explain why the person doesn't get medication or does get medication. The answer is no. General physicians, gynecologists, neurologists, pediatricians, these are the people that prescribe the majority of psych medications to children and adults in the United States. The last thing I'd say, and this is also crucial, the very large majority of non-pharmacotherapy is provided by non-psychiatrists. Let me just explain that. Psychiatrists in today's world provide almost no talk therapy. It's provided by social workers and nurses and psychologists and other licensed counselors and therapists, different licensing in different states, that provide talk therapy and other kinds of non-medication therapies in different forms, including individual and group therapy, family therapy, dialectical behavior therapy, residential therapies, and so on. So it's important to understand that even if the person has seen a psychiatrist don't assume that the person has had or been evaluated for ongoing psychotherapy. I'm a psychiatric social worker. I have a doctorate in psychology, but my license is a social worker in New York State, and so I have a bias myself towards social work. And there are a lot of advantages to a social work evaluation, but first and foremost, it is holistic. It looks at systemic biopsychosocial issues within the person's life. It evaluates in an integrative way, and it's the best thing, frankly, to counter the PSI. Not least of which because it also considers cultural sensitivity. The limitation of a social work evaluation is that psychopathology is regarded as secondary to the client's family and community context. However, a good social worker will have more than enough clinical experience to pick up and properly document psychiatric issues. There are also obviously medical evaluations that are possible. Medical evaluations are supposed to be very holistic, right? When you go to your primary caregiver every year, that primary caregiver is supposed to, in theory, touch on every area of health that could be of concern, especially if they're red flag issues that would then allow the primary care physician to either to treat you through their own practice or to refer you out for specialty care. This could be particularly important for endocrine and other systems that may cause aberrant behavior, such as hypothyroidism, undetected brain tumors, and so on, which are neurological symptoms, which may appear through neurological symptoms. The problem here is that there is a very high rate of medical error in the United States with physicians, even with specialists. And the most obvious is the failure of primary care physicians to red flag psychiatric problems. And where I see this the most is with children and adolescents. I've seen hundreds and hundreds of children and adolescents over the years with various kinds of problems. The one thing that children and adolescents all have in common within the healthcare system is that they see doctors. An adult may have a problem for many, many years, a particular kind of healthcare problem, whatever it might be. That person may not go to a doctor for 5, 10, 15 years for all sorts of reasons. That's not true for children. Children and adolescents have to see physicians once a year, twice a year, whatever it is. In the vast, vast majority of these cases, the pediatrician, the primary care physician for these children and adolescents, have missed out on even overt, clearly recognizable psychiatric and mental health problems, including debilitating anxiety, depression, and so on. So medical evaluations, which are supposed to be holistic, sound good, but there is a concern that it misses out on medical issues, healthcare issues, and this is really borne out through research. Another kind of evaluation that sometimes lawyers are less familiar with because it's integrated in other kinds of evaluations to counter PSIs is psychodynamic evaluations. These are, it's really a systemic study of the psychological forces that underlie human behavior, feelings, and emotions, and how they might relate to early experiences in the client's life. It may have a special emphasis on the dynamic relations between conscious motivation and unconscious motivation. It can be extremely helpful in providing a humanistic understanding about feelings, privations, traumas, thoughts, aspirations, hopes, dreams, frustrations, stresses, all sorts of confusions and disappointments that the clients may have had, but also to underline a sense of security, stability, and safety that the client may have had or may have lost at some point. Psychodynamic evaluations can provide core insights and deeper, more comprehensive understanding about the client, and may even tell us about the client's judgment and decision-making. One of the great limitations about psychodynamics and psychoanalysis in general, quite frankly, is that there's somewhat of a blur between normative behavior and psychopathology. Psychoanalysis is not in the mainstream with psychiatrists for decades and decades until the early 80s. Almost every psychiatrist had psychoanalytic and or psychodynamic training. Today, it's extremely unusual. In fact, if you go to psychoanalytic institutes in New York or elsewhere or any psychodynamically informed program, you have non-psychiatrists. You have a psychologist, social worker, nurses, a lot of educators, clinicians who want to be licensed under another format. But a good clinician should have a consideration of psychodynamics. They should have a good consideration of unconscious psychological forces that reflect the client's feelings and emotions and so on, because it gives so much insight into the person's childhood inner turmoil, their perceptions of their childhood and adolescence, and how it ultimately informs their judgment and decision-making in adulthood. Obviously, again, I'm a mitigation expert, so I advocate for mitigation as the best way, bar none, to counter the PSI. Certainly in the memorandum of law presented by the lawyer for sentencing purposes, it is crucial to interweave the criteria of 18 U.S.C. 3553A into key mitigation factors outlined from the mitigation report. This will afford the prosecutor and judge to consider and understand the client's psychosocial issues as legal mitigating factors rather than simply a background information established for the sake of general legal argument. Criminal mitigation is not simply an effective tool for the sake of argument, therefore, but really this underpinning that should complement and balance the memorandum of law presented by the criminal defense lawyer. Certainly post-Booker, the court now has unfettered discretion to consider any and all mitigation at sentencing, and a wide range of arguments can now be considered. So, mitigation is clearly front and center. The problem with mitigation, if there's one limitation, is that it's not really used very much. Mitigation experts are used in the United States, but it tends to be in more serious cases, but even then, not always. I'm shocked by the number of cases I've seen where clients have come to me later, often because of their immigration consequences, actually from their criminal cases, and I say, the first thing I ask for is the mitigation report, because it provides so much information about the psychosocial history of the client, and it would give me a good leg to start on. And the client says, what's the mitigation report? And quite frankly, in many, many cases, the criminal defense lawyer has not even explained that this is an option, whether the client wants to go along with it or pay for it, or for whatever strategic reason, the client and lawyer decide not to use mitigation for the case. That's one thing, but it's a necessary tool, I think, and yet it's not really used regularly. I just want to give a little bit of overview of mitigation itself, because it's such a crucial area here for criminal defense in battling the PSI. Mitigation is a biopsychosocial evaluation of the client's social and psychological history, informed by the facts of the criminal case with appropriate recommendations as a means to minimize the negative legal outcome either in court or with a prosecutor. Mitigating circumstances reduces the degree of moral culpability or blame, which in fairness, sympathy, or mercy may lead to more favorable outcome for the defendant. So mitigation really looks at anything and everything, specifically for mitigation. And this stands, I think, in contrast to these other kinds of tools, such as a psychiatric report, such as a neuropsychological report, psychosexual report, and so on. It's not that those reports don't have value, but they're not specifically aimed at targeting the concerns for mitigation itself and for countering the PSI. There can be some advantage in bifurcating it in the sense that, you get a mitigation expert to look at anything and everything in the person's psychosocial background, but also have, for example, a neuropsychologist do a paper and pencil test that is seen as more objective. I'll tell you a very interesting outcome of this, though. I had a case several years ago, and a colleague, this was a very serious case. It was a murder case by a gang member in New York who'd grown up with all sorts of terrible abuses and neglect in his childhood and adolescence, and it was a neighborhood with drugs and violence, a neglectful father, abuse in the home with a alcoholic mother, and so on. And the lawyer who I knew here, criminal defense lawyer, was very aware of my case and had a case with very, very similar issues with a client who presented in a very, very similar way. And he got for that case a neuropsychologist to do a battery of tests and then write a short conclusion. And he said, would you like to read it? You can get a sense of the neuropsychological outcome from these tests. I said, of course. And what was absolutely amazing to me was that the neuropsychologist's conclusions for her client were exactly the same conclusions that I had for my client without me using any objective testing. In other words, through a good clinical evaluation, you can get almost everything you need. And I'm not trying to downplay the positives of other kind of testing or other kinds of evaluations, don't misunderstand me. But it's crucial to understand that a good clinical evaluation, you get so much. It's never too early, it's never too late to use mitigation. It should be done as early as possible so that the report can precede the PSI and be available for review by the probation officer as background information. The same strategy can be employed with regard to the prosecutor. That is, before the prosecutor forms biases or prejudices against the client, the prosecutor can read the mitigation report and become disabused of assumptions that may be false or not fully held by fact. And this is one of the most important purposes of mitigation in countering the PSI, to allow the prosecutor and ultimately the judge to have their own biases challenged because of the color of your client's skin or the clothes they wear or how they talk, their accent, their presentation, anything and everything. As I said, we see this with white-collar cases where the client is really demonized simply by his particular resume, so to speak. We want to humanize the client through a sympathetic narrative and induce empathy, documenting the life of the client, contextualizing his conduct, explaining family issues, dependency, illustrating community, educational, employment ties, expressing remorse and regret. These are the key purposes. Especially for the PSI countering, many times the client does not express himself fully or even accurately. And a clinician can have the client feel at ease and develop a sense of trust so they can express themselves. And this allows professional expression to replace self-expression so that the mitigation report can encompass areas of thoughts and feelings that the client has inside that he or she can't express on her own. Just like the client has a criminal defense lawyer, because the law is complicated, the law is counterintuitive, it's impossible to navigate on your own, you get a criminal defense lawyer. Similarly, psychological, emotional health issues are very difficult to navigate and understand and explain on your own, and so you have someone who you can speak with who can do this on your behalf. And the mitigation report is not just a mental health report to counter the PSI. It's supposed to integrate all sorts of issues and areas from the person's life to counter the PSI in a very holistic way. The PSI is done by probation officers who I said are not clinicians. They haven't studied clinical work in psychology, psychiatry, social work, whatever, and they don't claim to be. The mitigation report serves, therefore, to integrate various other reports, documents, and also serve as a clinical expert. And I say this because, very often we have clients with criminal defense lawyers who want to submit documents regarding the client's employment history, other vocational issues, education, academic concerns, and so on. And one of the nice things about a mitigation report encountering the PSI is that it integrates into one single document, something that's digestible, and really allows the reader, adjudicator, prosecutor, whoever it is, to absorb this information in one contained manner. The client should be prepared, just like the client should be prepared for the PSI. With the probation officer, the client should be prepared for the mitigation expert, to be in the right frame of mind, to eliminate anger and defensiveness, to allow him to open up, to be honest. And the client really has that opportunity to benefit, especially if they have mental health issues, if they've suffered extreme hardships, traumas, interfamily dependence. The client may have poor language or communication skills. The client may have poor self-care skills, in general, poor executive functioning. They may fear authority, and so on. So you may have a client who has perhaps tried to be very open and honest with the probation officer, but the client just doesn't have the wherewithal, doesn't have the ability to provide and reflect his issues in an accurate way, and therefore the PSI is not what it should be. The purpose today has been to provide what I think is one of the most problematic issues, and that is probation officers who prepare in good faith often pre-sentence investigation reports that are very deficient in a wide range of areas. And it becomes incumbent upon the criminal defense lawyer, with the assistance of the mitigation expert who has a clinical ability to interview the client and elicit information in a way to counter the PSI and ultimately provide a much more accurate, a much more fair and balanced understanding of who this client is, so that the client will have the opportunity to express himself in a way that really reflects his contrition, but any and all mitigating factors, both early in the process so that the probation officer really understands who he's speaking to in a very clear way, but also so that the prosecutor and judge ultimately will understand as well the client in a humanistic and fair manner. Please, as I say in all my programs, don't hesitate to email me if you'd like a redacted sample. My information is in the YouTube description. I hope this was helpful to you. If you do want to contact me by phone, do so. If you want to contact me by email, just put something clear in the subject line so I know it's you and it's not spam, and I'll be more than happy to answer. Thank you, and I will see you next time.